Good afternoon, everyone. It is a privilege for me to welcome you all on behalf of KFCRI for this brainstorming session on the topic of investment arbitration by our intern, Manoj V. Amritraj, who is currently pursuing BBA LLB honors in School of Excellence in Law, Chennai. Over to you, Manoj.
Thank you, Ranjini. Good morning, everyone. Today we'll be seeing about investment arbitrations and their functions and operations in global and domestic markets and how they actually operate inside this legal field. Starting with it, basically an investment arbitration usually arises out of investment treaties that are entered into by the host state and the foreign investors, with the view to make an investment by one party to another to venture the business opportunities between the state and the investors who are willing to venture their investments and funds risking over the host state. And investment arbitration has four fundamental pillars which actually creates the need as well as the modus operandi for an investment arbitration. First is that the governing principle as well as the agreed terms and conditions which are being laid in the investment treaty, which can be in bilateral treaty by the host state as well as the foreign investor. And second is the national law of the host state. For example, Indian domestic law can be also said. And third is that independent investment agreement, where a particular host state enters into an independent investment agreement for a particular purpose or a particular project. This can be referred under this. For example, Indian government has entered a particular agreement with that of Sri Lankan government for creating and developing underground sewage waste management systems, which is an independent investment agreement between the states as well as the foreign investors. Fourth is that choice of independent and individual arbitrators and arbitral tribunals. For example, here in the investment arbitrations, the parties, either the host state or the foreign investor, have their liberty to appoint independent arbitrators and arbitral tribunals to amicably settle their investment disputes between them and continue their business opportunity without being tormented by the traditional court proceedings. And procedures and enforcement of international investment arbitrations basically adopts the body of procedures and enforcement from the international commercial arbitrations, which has been prevalent, as the word investment itself is derived is a subpart of commercial and applies the same to the disputes between foreign investors and the host states. The key aspect which governs the investment arbitration is that the transparent and private adjudicating model, which is suitable for the international commercial arbitrations, into the limit of the government. Where you can see that international arbitrations is a process or a model through which an investor seeks his redressal without being tormented or being overpressured by the cost which has been related in the conventional and traditional redressal seeking mechanism through international public laws, thereby giving an individual investor and private parties a chance to seek redressal for treatment according to them by the government of India is also being applied, where government of India is promoting international investment arbitrations through their adding their in arbitration clauses as well as the separate arbitration agreements with all their international investment treaties. For example, recently our Indian government has entered into an agreement between UAE and the Indian government has entered into a particular investment objectives, where they have included and they have set aside certain procedures for following inside an arbitrations when and what are the grounds for which they can seek an arbitrations in international investment arbitrations. So it is being an inevitable development in the field of ADR. Investment arbitrations is going to be an inevitable part of every investment treaties and agreements between an global individual as well as a global community. And procedures, when we come to procedures, the parties to an investment arbitrations are free to engage the independent arbitrator to make what are their concerns and the governmental decisions. These dispute resolutions clause, which are common to all the investment arbitrations, are carefully drafted either to concur to the institutional arbitrator or ad hoc format, or depending on the nation and its relevant treaties. For example, India also allows ad hoc arbitrations based on the investment treaties, which is an fundamental part or the beginning part of an international investment arbitrations. The selection of an arbitral tribunal is a very critical step. In the process of selecting a arbitral tribunal for an international investment arbitration is critical because the arbitrators are basically persons who are, adjudicate the disputes. But here the parties are so concerned about their approach because even though we avoid the rigid traditional systems, legal system has its own unique approaches in which arbitrators in the investment arbitration adapt to two particularly major approaches. One is pro-state approach, and the second one is pro-investor approach. Most of the investors who prefer pro-investments investors approach, as it is more cost efficiency and it is also feasible and more flexible when compared to pro-states approach. The ICDS also provides a panel of arbitrators for which parties may select an arbitrator of their choice. And the parties to an investment arbitration are usually extremely cautious about their choice of arbitrator. As I mentioned before, it has been very crucial part is that the choice of arbitrator will determine the course of your arbitral proceeding in an international investment dispute, where every and each step is costly, as there is many legal obligations as well as the cost of proceeding when compared to the traditional methods, it is low. But even though it is a cost to one private investor, which is being avoided by taking care of the crucial step of appointment of the arbitrators. The international commercial arbitration, investment arbitrations are mainly governed by the following treaties. First is NAFTA and unilateral, and last is ICES. If not, they will be governed by mandatory provisions of national law. For example, if there is a particular provision in the particular investment arbitration is that in investment arbitration agreement is that any mandate provision which is being in the host state, uh, the arbitration should also accommodate that provision and should apply that. For example, uh, India has its own governing provisions which are mandate, especially for the securities. So, which can be implemented in investment arbitrations, even though these treaties are not covering. And ad hoc investment arbitrations. The investment arbitrations can be ad hoc, like to be in the International Chamber of Commerce (ICC) and the London Court of International Arbitration (LCIA) and Singapore International Arbitration Centers, where these are the institutions which provide an platform for an ad hoc arbitrations where both the parties, like example, the state, host state, as well as the private individual who's the investor, is being protected, as well as the procedure is being effectively implemented through these centers, namely these centers. And the confidentiality. When we come to the confidentiality, arbitration is most concerned with the confidentiality of the parties, as it is an main part of an arbitration, as well as which is concerning about the investment. Even though we follow international public law, when it comes under the international investment arbitrations, Still, the foundational treaties, which have been mentioned in the previous slides, is silent on the confidentiality. No confidentiality is practiced in the investment arbitration, which is understandable in given disputes and state interest. But here, my suggestion is that when it comes to investment, it investment as well as an global transaction, the confidentiality of a dispute is a vital thing, as because the main transaction value and the uh, public image value of both the parties are at the stake. So international arbitration is available in public domain, where you can see an international arbitration uh, awards are available always in a public domain, which I previously mentioned. The law is silent about international awards which are being awarded, which is public in nature. But I suggest certain awards should be in the manner of confidentiality, subject to the consent of both the parties. But making the such change will also affect the interest of other investors who rely, or the stakeholders who rely on uh, both the parties. So that is an counteracting disadvantage over making confidentiality in international public law subject, which is investment arbitrations. And as I said before, the international investment arbitrations involve huge amount of funding, and third party funding is also allowed, since investment arbitration is costly, and the practice to have cover the individual cost and the institutional tribunal and the legal fee for the councils. The parties often obtain a third party funding, and you may also known as it's also known as crowdfunding also, to fund the arbitration proceedings as well as to proceed with the business transactions. In the case of Board of Trustees of the Port of Kolkata versus Louis Dreyfus Amateurs, where the cause of action, whether contractual or not, is grounded on the state to guarantee and assure, and it is not an commercial in nature, where this states that the roots of investment arbitration are in the international public law and the obligation of the state and administrative law. Here it is very clear that India has adopted an approach, even though we have not accepted the ICDS, IS, ICSID, even though Indian judiciary has adopted the rules where the host state is responsible for the investment made by the foreign investor, as it is a public international law subject as well as administrative law subject, and it's the obligation of the state to resolve the dispute. And it is furthermore, it is an obligation of the state to provide a platform amicably to amicably settle a particular investment arbitration dispute when it comes to a global transaction. Uh, the non-interventional approach of Indian courts in relation to the bilateral treaties of arbitration. Indian courts have recognized their limits in interfering with the investment arbitrations, which lead to respective jurisdiction to shift closer to the investor-friendly environment as promised under the bilateral treaties. Where Indian judiciary has adopted a particular approach by which the liberty of an foreign individual or a global citizen to invest in a particular host state is being in a flexible manner, and it is being governed with an laissez-faire method, but without being overwhelmingly crumbed as well as making it rigid, because Indian courts have an obligation towards the Ministry of Finance as well as the financial institutions which govern the Indian economy, is that the Indian courts or the Indian judicial process should not limit the liquidation as well as the fund flow velocity inside an Indian economy and outside the global economy too. So investment friendly nature only our Indian judiciary has accepted it, and that's all with it. I'm completing my presentation. Hope you have all understood about investment arbitrations. Thank you.
Thank you, Manoj. Your presentation on the topic of investment arbitration is enlightening and informative. Your perspectives and insights have given us a deeper understanding on the subject matter. We are grateful for the knowledge you have imparted, and we appreciate the time and effort you put into for preparing it. Thank you.